Anuj and I have been brainstorming some ideas about how we can continue with some of the topics discussed yesterday, but also take it on another path as well in a related way. And we decided that we think an interesting approach could be to have four provocations, which are linked to the topics that we set for today's session, which is about legal pluralism and personal law. So looking at crypto law from that perspective. So if for those who have access to it, you could take a look at the Notion document. If you scroll down to the the specific date on Monday, 19th October, you can see it. And I'm going to, for the convenience of everyone here, I'll also post it in the chat.
Yeah, thanks, Morshed, for that. And on that, we were thinking of uh, looking at maybe a concrete case study or two to kind of wrap the entire conversation around. So each of the provocation would be trying to look at some, like we were thinking of the Prockpow situation that happened, and also um, um, the Keros case 302. Both are pretty interesting. We can go either. I think Prockpow might be more easier to talk about. It's more well known, and it is directly with Ethereum than a dApp built on top of it. So we can just use that example and then use the legal pluralism angle with something that we note down the provocations to discuss, so that we were thinking about that. What do you all think about that?
Sounds good.
So I'm on the Notion page right now. So where should I be looking on that page?
So if you scroll to the bottom, you'll see Monday, 19th October 2020.
Oh yeah, okay.
And you'll see that there's a list of provocations.
Oh yeah, great.
Yeah, I just turned silent because I'm in the middle of reading. I'm sorry. I think that I didn't do the task well. I should have listened to you two talk instead of jumping to the Notion page.
No, I think you did the right thing.
You want to read them out loud just while we're going through them, or is that, do we just want to take a little time to, what do you want to do?
I think it would be nice if, because it's some of them are a bit longer than others, to provide a bit of context. And I also provided some links to case studies as we were discussing. So for instance, discussions regarding ProgPow. So maybe if we take, let's say, 5 to 8 minutes to just read this. I don't know if that's I can also read, like I can read two of them and Anuj can read two of them if that's helpful for anyone.
Maybe we can just like summarize them for everyone.
Yeah,
I don't
sure.
know.
Yeah,
I don't
yeah.
think asking everyone to do independent reading is the best start.
That's a great idea. Also, just to briefly introduce Samir to us. Samir is joining us as one of the facilitators and one of the stewards for the Future Law Virtual Summit. Basically, he's here to ease the communication and to weave the things together whenever necessary. Thank you for joining, Samir.
Yeah, it's a pleasure. I'm curious to see what we're going to be talking about today.
So I'll summarize the first two, and then maybe Anuj can do the next two. The first one is basically to distinguish whether crypto law concerns legal norms or social norms, and uh, whether that distinction can even be drawn in this space, which is often done when we look at questions of legal pluralism, about whether something falls within the domain of culture and religion and custom rather than in what many would consider law. And how would you draw that distinction? What is the basis by which we draw this distinction between a legal norm and a social norm? The second question is basically about whether crypto law has a conception of positive rights or not. And here we're concerned, like the provocation is that crypto law seems to be primarily concerned with negative rights. So in the sense that it's more concerned about freedom from things happening to a blockchain or a blockchain community. So for instance, if we look at the specific conversation regarding decentralized autonomous organizations, it's about freedom from having to register, freedom from being held liable by default, for instance, or being considered a general partnership by default. And whether there is, for instance, a positive articulation possible, and whether that's needed, that's sort of what the second question is getting towards. I think the example that we provided is this ProgPow discussion between, let's say, the idea that at its core, if we see it as being from a positive angle, that maybe it can contribute to Ethereum being less less plutocratic and more decentralized, as some claim, or we take a more negative spin on it and see this as some form of, as some have called it, like a socialist redistribution. And so that's, I think, like again, an interesting way of trying to understand this. Those are the first two. So first, legal norms and social norms, and the second, positive rights and negative rights, and whether crypto law is mainly concerned just with negative rights. Anuj, do you want to?
Yeah, maybe just before that, I realized maybe everybody might not be aware with Provisional. So just a brief of what happened was there was this suggestion on upgrading the proof of work algorithm. So there was this if there else company who were doing some interesting work in this space on both like chip design and the software as well. So they had made some interesting suggestions on how we can make the algorithm in a way that is more GPU friendly, less asset friendly, which means that more and more people would be able to, I wouldn't say anybody, but at least more than what it is now, would be able to buy a GPU and create their own rig and take part in participate in mining. So that would be more in line with one of the themes behind Ethereum when it started. Like people try to be more distributed in terms of mining, who get the rewards than say Bitcoin. So that was the idea with this suggestion, and this started, if I remember correctly, I think 2018 towards the end, maybe fall of 2018, I think suggested, and first time, and then there was discussion going back and forth around this. So while I mean, technically the audits that happened, even independently, two audits happened. They didn't found pros and cons, but not any like major bugs. Even there was a test net which ran properly, and the way it happened was it kind of was accepted, but not finalized in the EIP, which means that it was there for consideration, but doesn't mean that people could actually deploy this code-based. So, but there was a lot of confusion around this because everybody understood the difference. On top of that, some people felt it was like snuck in through all core dev calls, not properly, seriously discussed, and a community was asked. And also, there was a huge pushback on that idea, which Morshed mentioned, that if this happens, we would be unnecessarily redistributing, any future rewards to more people. If it's, we should be more careful around these things because it can make or break Ethereum. So there was this kind of, I would say, mm, for lack of better words, and it's controversial, more like libertarian angle to this. And also there was a personal, like, kind of like ad hominem-ish kind of attack for I can't remember her name, the lady who was behind Christie. So Christie, yeah, she is the one who is the architect of, and I think she's the lead in the Evdefers company. And because she worked with Craig Wright, Craig Wright is the person who claimed to be Satoshi, and generally not the best person in the world, let's just say that. I mean, there's a quite reasonable thing to have pushback against Craig Wright. But she just worked with Craig Wright, from what I understand. I don't know her personally, is that she's interested in like cool technical problems, and they had their problems. She contracted as a contractor work. So the community was some people in the Ethereum community, like, I know Amin and all, they were like up in arms. Oh my God, I don't like this. This person worked with somebody so terrible. How can we accept her? Which is, I would argue not the best way because it's more ad hominem. So there was this libertarian critique that we shouldn't distribute what if things break. There was the ad hominem attack that she worked on that. And there was the general sense of, like some parts of the community sense of like fear and anguish that, oh, it got accepted, but we don't know, nobody asked us, or it's really properly talked about, but it was not finalized. That nobody was getting the code from their client. I don't think everybody realized that. So we realized, like in crypto, as Morshed was saying, you have all these kinds of negative rights, which are more like liberties. Like, for example, to put in a regular term, not crypto, it's like you can think of a negative right. I don't know if everybody is aware of that. If they are, feel free to stop me. I would not talk about it. So basic idea is that you have the right to choose or not to choose, the freedom of choosing a religion, freedom to believe or not, or freedom to express freely or not. But this does not incur on others to have a duty to provide you. So, for example, you are free to have a religion, but that does not mean somebody else, or your neighbor or the state, has to come and give you this right or give you a religion. I mean, you are free to not even have it, right? Whereas this is a negative liberty, but the positive liberty is the entitlement, more like, which is like you have the right to fair trial, for example. The state have to give you one account if you cannot afford one, for example, like in the movies. That's more an entitlement, a positive right. So positive rights always kind of incur upon others to have a duty to provide it. So in the case of crypto, you can think of it interestingly from this angle, because when you have your, for example, Ether or Bitcoin or whatever, you are free to spend it ideally to give it to somebody else. But if you make a mistake or if something happens, nobody else has a duty to give you something, like, so it's less an entitlement, more a liberty. Now we could get into the weeds and we will later if the question. So maybe, yeah, that's on the proc power, but so Morshed, if you want to add anything to what I said, feel free.
No, I think that's good. I think maybe it's just helpful to, again, like in one sentence, summarize, the distinction we're trying to draw here. So the first one is whether it's useful to look at crypto law as something between legal norms and social norms, and whether there is a distinction, and whether even that distinction is meaningful. I think that's one question. And the second one is about positive rights versus negative rights when we look at crypto law, with ProgPow being an interesting example of that. I think that's the first two issues. Should we have a discussion about this first before going into questions 3 or 4, or would it be helpful to um, also just mention them up front?
Morshed, could I maybe suggest that what we do is go into quick breakouts in smaller groups of 3 or 4 people, just to discuss a little bit and digest what you shared and Anuj shared about these problems. How does that sound? For just about 10 minutes?
I think that's a great idea. Yeah, I think
And
we have enough people to do that. Yeah.
Yeah. So Alyssa, if you could make breakout rooms of let's say 3 people, and for about 10 minutes each, and then as a suggestion, just share with each other, what came to mind. What are some of the interesting points that came up, from what Morshed shared or Anuj, and or look at the Notion document as well. And then afterwards, we can then sort of share what we talked about in the chat, and then continue the discussion in plenary. I think that might be just a little bit smoother for us to talk. That cool? Okay. I see the breakout rooms have opened. Another suggestion before I just open up the floor to anyone. Should we maybe, just because I'm just curious to hear what came up in the chat, if I could invite everyone to just finish the prompt. So something interesting I learned. So just give me a second. So this is the prompt, just so we can, just anything that came up. So the prompt is something interesting I learned in the discussion, and just put it in the prompt so we get a sense for what sparked with you, just so we can see what people were thinking.
I love that I get one more chat application because that's just what I needed.
Should we just share that here in the chat, or should we say it out loud?
What do you think, Morshed?
I like having it written because I think it's yeah, exactly.
Maybe as a start, and then we can open up the discussion.
Great. Okay, John included one already. I think others maybe.
I think on our group, Grace had some wonderful things to say. Maybe you want to just type in what you told me. I think it's great. Oh yeah, thank you.
Anuj,
I mean,
you want to repeat that? I had some troubles hearing you.
I mean, what was clear is that this case, I've seen this case happen inside of political parties, the exact same thing. The people who have power do everything they can to prevent the people who don't have power. And if those people leave, that's great. And so it seems like in the same way that Bitcoin has accelerated the the damage to the environment and the huge gaps between the haves and the have-nots that we see in our financial systems, like it's accelerated them and made them faster. The same way these DAOs and democratic system has accelerated and amplified the really nasty aspects of our democracies that aren't working. Like it's almost like it took them. It's almost like a caricature of the bad parts of our democracy and law.
But is this actually the bad aspect of democracy, or is it rather the bad aspect of capitalism? Just wondering. Yeah,
I would say representative democracy as it's implemented today. You know, the example I gave was of a political party in my country, in Israel, of a parliamentary, of these people who had a small party, and as it grew, they did everything they could to keep the number of seats they had, but not allow people to join the party because it would change their requirement.
Got it.
So it's democracy as it's implemented today, and the gaming that goes on.
So I'd like to suggest that we go over the prompts one by one and have some discussion about them.
I think that's a great idea. I was going to.
Can we start with the first one? Maybe this question about norms versus law and kind of the difference and what is crypto law made of? Is it made of law? Is it made of norms? How should we talk about it?
I think it's a good idea.
So my question would be, when you say crypto law, what do you actually mean? What are you referring to?
Sure. When I say crypto law, I'm talking about culture and other stuff that constrains, modifies, modulates, operates on structures, or somehow modifies interpersonal conflict and disputes in crypto and how that plays out. And so anything that kind of constrains how conflict in crypto plays out, I refer to that as like a part of crypto law. And then if you put it all together, all the constraints on interpersonal conflict and disputes, I think of that as crypto law. And then norms and rule enforcement have a legal side to it in as far as they involve conflict. Like someone's interpreting rules, trying to see if your behavior is a violation, and then bringing beef to you. Like that's kind of the rule pattern of law. But there's many different legal traditions and many different legal forms that are possible and that we are familiar with and that exist in crypto law. In my opinion, there are really important crypto legal norms, but there's also lots of really important crypto legal forms that are not norms, and crypto law realities that are not norms. And in general, to me, I would also say that about generally about law. There's a lot of non-norm, non-rule enforcement legal forms.
So interesting, because the way you describe it, I mean, there's plenty of these new netiquettes popping up on the internet because we have so many internet communities lately. And a lot of times these rules are basically composed just so that we know how to approach when a dispute arises. And I wonder whether these type of an etiquette, just because it applies to crypto community specifically, is now being called crypto law.
Well, firstly, I want to examine like whether or not it is improper or proper to call that kind of dispute resolution terms as a part of law or not, right? I personally contend that it's super important that we recognize that kind of thing as a legal form. I wouldn't necessarily call it the law because honestly, like I probably wouldn't consider it binding. Like I would probably dispute every term in it. Like the law is not going to be like something that you write down, but these kinds of legal forms are super useful in managing conflict. Like people like to have like anti-harassment policies that are written down so that if someone is an asshole, they can point to the policy. It helps you in a little argument. But just because the law uses this policy doesn't make that policy the law exactly, right? And so I would say, to disqualify legal language from the setting would be wrong, but it would also be wrong to say that these terms of your community are the law. I mean, they're just some stipulations, some claims, some hopes, some kind of declaration, some kind of terms and conditions, which is like at best going to be a kind of contract law binder, or maybe even better, but it's not going to be the law exactly. It's just like some terms, disclaimers, policies, etc.
But a brief question on when you're referring to crypto law, are you referring to a general crypto law, or is it in the same way? Could it also be a community specific crypto law, or protocol specific crypto law, or are you here looking for or want to discuss a general crypto law, like
That's a great question. I mean, it depends on the level of the conversation. Certainly, when we're talking analytically, we see that different crypto projects have different legal matrices, and they have very unique, distinct legal kind of history, practices, norms, etc. But also, they also have cross-pollination, and there's also norms that spread between communities, and there's also basic legal realities that exist just because of the nature of conflict over crypto protocols. And so there's some parts of crypto law just analytically that are going to be the same across projects, and some parts that are going to be different just analytically. But then there's this other question of, if we're going to intervene in crypto law, are there norms that we want that are important enough that it should apply to all crypto projects? And I would say yes. To me, the norm against genocide is important enough that it should apply to all crypto projects and all crypto law. There's lots of other examples, but like, I'm going out there extreme and being extreme. So just to make it clear that, there actually probably is some law that we want to apply to all crypto, and not just some.
So I think this goes squarely to the last two provocations on the document. Basically, the idea in that is that, as an example, uh, instead of just the private and the public law that we have in most jurisdictions in the world, in certain parts, especially parts that have been an English colony, like in Southeast Asia, the subcontinent, Indian subcontinent, where Morshed and I we are from, we have also personal law. So personal law is basically this angle where it would be not more of a community-based, like norms and etiquettes that could be done. So you could even invoke say, somebody in your family, like a matriarch or patriarch, to mediate. You could have a local priest to mediate that, or we have like kind of local community courts kind of to do that. And the thing is, also there's another interesting angle is that as long as it's not codified, it might be written but not codified in a kind of formal way, the state cannot intervene. So it's a way of doing in a way that we have. I think it's interesting for crypto because we do not have, say in India, a uniform civil code that applies to all Indians. We don't have it. So, but we have some things that are common, like the fundamental rights, but you can have your own personal laws. So what happens is as long as, so, and you could think of it in terms of crypto, like each, say, crypto community, or each DApp for that matter, specific, can have their own tradition, own culture, own etiquette, and their own norms. And there could be some, like in India, fundamental rights that cannot be, like for example, there were cases around specific communities tried to do something that were kind of misogynist. So then the government said, okay, this is where we stop. You cannot like this is fundamental right. Everybody is treated pretty fair, equally, and all that. I think somebody has, there's a background noise coming from somewhere. No, okay, thanks. So, so, so yeah. So the thing is, the state would not do that, and the thing is, historically, it happened just as a background because when the English came, we already had existing laws and they were in conflict with English law. So it's a kind of a compromise that happened over some years, like 50, 60 years, and it's always contested where should be the space of personal law and where public and private. So it's in a way you get something where in the case of Ethereum, you would not think that, I mean, if you look at this perspective, that Ethereum itself will be like the one final, like uniform civil code, and all the dApps are their own little things. But rather than personal law, it's side by side, you would say. So Ethereum is also Ethereum in its own practices, norms, and all that will be side by side in terms of primacy to a particular dApp. It depends on the context, really. In some context, you have to consider some dApp etiquette and norms than the Ethereum. And then you would allow different communities to choose their own, for example, education, how they would go about it. So I thought this is interesting related to the last things we were talking about, that should there be one common crypto law. I mean, I am more, this is why we also, one of the titles of today was legal pluralism. And it's interesting in India and in Africa also, Sudan, I know this is the case, for example, because you have multiple religious groups. And the thing is, you don't want to have the same law for everybody because they already have a tradition-based system, and you don't want to just cancel that out. And on top of that, there's the idea that um, for some people, you could consider their religious identity, say that your identity as a Buddhist, for example, is so primary that you are, say, Chinese or Indian or French after that. So you could think you identify with all Buddhists in the world first and foremost, than say all French in the world, or India, or whichever country you happen to live in and have citizenship of. So this personal angle gives you a way of not having to associate the legal matrix with what comes from the country, but I mean there are influences, but not totally determined, but completely determined by it. You also have a way of determining your identity based on the global identity, because it's religions, are more of a, in some ways you could argue, have a kind of a virtual jurisdiction, if I might say. It's not accurate to say that what jurisdiction have, because it's not like demarcated by the physical borders of the country, right? I mean, you don't stop being a whichever religion you believe you want to be based on just entering or leaving a country. You might not be able to be free to exercise it in some places. Some might be more free, some other places. Opportunity might be more, but you still, from a belief angle, you still are whatever religion you want to be. So the idea that you could let people have a sense of identity and how they want to be judged in in the eyes of who, based on a more global, a more community oriented, so we could call it global and local perspective than a state oriented thing. I think that's interesting in terms of crypto, because when you have say ether, you're not a French ether holder or a, I don't know, the cyberspace is in some ways agnostic to the nation state boundaries. And the I think the Judeo-Christian angle to that is libertarianism. Let's not have the state and hate the state. What I'm suggesting is there's another way of not having the state involved, which does not involve libertarianism, which is legal pluralism. You know, but you still do not have the state as a kind of monopoly that can give the law, but at the same time, you don't get into that kind of angle that libertarians would have. I hope that makes sense.
If I may add something to what Anuj said, I think another aspect of why it's interesting to look at religion, other than having a different narrative than libertarianism, is the fact that if we look at how personal laws are regulated in different parts of the world, in some cases, you obviously have no clear-cut distinction or a very weak distinction between a personal law and the state civil law. But in some jurisdictions, like where both Anuj and I are from, you do have a host of personal laws, which are quite interesting to look at when we consider even discussions about how do we create law for crypto. So for instance, personally, I'm involved in this project which is trying to draft, and Andrea is as well, to draft model legislation for DAOs. And here, the discussion so far is very much like how you would consider the creation of any new entity, whether that's a limited liability company, public limited liability company, and so on. That's a very particular way of looking at creating a new or entity form. However, another way could be like the way that personal laws are regulated, where the state says, this domain, and then specifies a particular domain, for instance, succession and inheritance, and says this domain is going to be regulated by a particular community, and the adherents anyone who belongs to this community follows their particular set of rules for governing this particular issue. So then you end up creating a greater space for self-governance, arguably. And that's, so without being prescriptive, you're creating the space for self-governance because you carve out this whole issue from it. And it's not just limited to obviously succession and inheritance, but it can be other types of property relations. Of course, in the case of religion, it's also about things like marriage. But we can think of many different property relations that is governed by personal laws that are carved out and thus given the freedom and the space to govern according to the rules of that particular community. I think that's also one of the interesting ways of trying to conceive, how do we see this space to proceed?
That's very interesting. I like that.
I'm sorry, Angela. What were you
Because I mean, for token engineers, it's very so currently there is this paradigm of the boundaries when designing an ecosystem are pretty important. So defining the policies, and this is looking very much from a building point of view. And I also think what we are currently see that communities or protocols are trying to define their policies is very much dedicated to a building phase, where in some protocols we are currently seeing something different emerge, which is we have first representatives for users taking part in governance. And this could lead, I guess, in this direction of having different laws for different user groups who define their own way of limiting or enabling behavior according to their needs or to their goals. And I'd say perhaps this is something that comes a little bit later down the road. So this attention towards, okay, we cannot only define it from the protocols or communities total point of view, but rather than from different users' angles. That's very interesting.
I think that, sorry, no, go, Grace, you can go.
I always love the religion analogy, and because I live in a decentralized autonomous religion, right? I happen to belong to one of those, and although the religion itself is a DAO, it did create a centralized governance, right? So like this religion called the Jews created this country, which is a centralized country, but there wasn't any Pope to decide on that, right? It was this autonomous. And one of the things that's been really interesting for me is the parallels between the different protocols. So for example, you'd mentioned marriage. The marriage protocol is a consensus algorithm. And it's like that in many communities, right? You go and you have a public wedding so that enough agents can see that you're married and you don't need to go get a stamp from the government. It's like we all know, or you put a dot on your head or a ring on your finger, and then everybody knows, and it's like a consensus algorithm.
I love that point because of the fact that you know, when I got married in the former Soviet Union to in Uzbekistan to my wife, who comes from a system where registration is the most important thing, while in my own community, what's most important is exactly as you say, it's about consensus and about going through the procedure of like let's say an Islamic marriage ceremony. And so what's funny is that we needed to have both so that it has the maximum possible coverage, global coverage, right? Because otherwise it could be that just registration on paper might not be recognized in some places, which I think is quite amusing when we consider how we often tend to think that, you know, getting some sort of third-party paperwork is the be-all and end-all of what we try, of what you know, like of what is gives something legitimacy.
Yeah. And I think the other thing was, I mean, when I was doing documentation for Holochain, I was really impressed with how many of the kinds of distributed ledger, like for the distributed hash table kinds of algorithms had parallels in Jewish laws, things like rather than preventing bad actors from doing things like they do in the blockchain, rather we put sanctions on people. And religions do that. It's like, okay, first time you did that wrong, and law does that as well. You just get a warning, and then the second time, and then each agent can say, you know what, I know his reputation is like that, but I'm still willing to work with him. But, you know, that person belongs to this category of, you know, and religions have all those types of things. So as I've been looking at, you know, law and the legal aspects of governance, it seems to me that these protocols, like these rules about how you behave in certain circumstances, are very, you know, like this is what it's about, not the voting or the parliaments or the who makes the decisions, but actually these rules of interaction and having more flexibility within the rules of interaction around these sanctions instead of like you're just in or out. Like that always seems to me a real problem with blockchain law. It's like you're either forked or not forked, you're either in or out. There's none of this like gradual sanctions, which is what religions and laws usually have.
Yeah, exactly. And I think this is also referred to as, I think in the first provocation, I think Morshed mentioned, something that comes from sociology of law, which is the living law, so which is more like the kind of the norms of conduct, not just the norms of adjudication. Like, not just law doesn't just happen on courts, right, or on state offices and buildings. Happens in the street when you look at somebody's eyes, when you call somebody by their name. Literally calling somebody by their name is an experience in the law, because the name has to be acknowledged by others, and you have to be able to unique identify somebody. And interestingly, marriage is an interesting example, I think, even for crypto, because like in India, for Muslims, you can just go, you can do religious ceremony. But for Hindus, they had a problem where there was not enough of a way to even have a consensus on what would be constituting a marriage, because it differed so much. So the state ultimately ended up saying, okay, Hindus can do whatever they want, but they need a paper from the state as well. Because we couldn't decide which one is the correct Hindu way with the Muslims. So it's like only when consensus was not found on a community level, the state said, okay, we will step in and help you. But if you had, so it's not like the state comes and the community, the other way around. If the community cannot, then the state is like, okay, let me help you out with that. And I think that's a very, very interesting angle also in terms of like crypto thinking, each community having their own consensus, and only if they fail, then they can kind of appeal
And I
to
think
the more.
and I think the reason why this is so interesting is that it's not only like, that, oh, we are allowing self-governance and this is a positive thing. I think, obviously some of this ends up having a negative effect. So a very recent example is one, and connected to this Hindu law example that Anuj gives, is that, for instance, in some societies, you would have a secular rule of inheritance, and alongside that, you have different personal laws regarding inheritance, where, for instance, certain people, just because of their marital status or the fact that they don't have children, male children, might not be able to inherit property. And the dilemma that this causes is, on the one hand, you are ostensibly showing deference to the wishes of a particular community, but is that something that is good for the state overall? So at least in my home jurisdiction in Bangladesh, this was recently overturned by a Supreme Court decision where they intervened in centuries-old legislation to say, well, not century, almost a century-old legislation, to say that no, everyone has a right of inheritance, and that you cannot use the argument of personal law to try to curb that right of inheritance just because, let's say, someone is unmarried or doesn't have a child. And this was specifically with respect to Hindu law and with respect to unmarried Hindu women. And I thought that's like an interesting way of looking at this, where in some cases we can imagine how allowing, let's say, a crypto law to flourish by saying that, okay, this domain we are not going to, try to interfere in or try to impose some form of state law on. But at the same time, there can be reasons at some stage to say that, it's great that you self-govern, but this is leading to certain adverse social consequences, and we need to redraw this line between state law and personal law, or state law and crypto law, accordingly.
Why state law and not, like, say, like public law, or maybe external legal actors, or outside legal persons, like conflict with outside legal persons,
Can
or
I
like law from outside? There's kind of like, I'm not sure why, like, it has to be the state. It can be someone else who's supervising you and has the competent authority to step in.
Can I pick up on this, Vlad? Because I think that one of the things that is not discussed at all in this conversation is the question of the authority of law and where that comes from. And I think that the comparison with the theology makes much sense when you think of a mystical foundation of some sort of law that you also, I think, in any secular system still have in some way. But if you really think of this historically in a very broad brushed way, then you would say you have a religious grounding of authority, and religion is law because it has a grounding in the ideal of religion, and the authority comes from the believers in this system. And then you have in a
No,
natural
I mean,
law version of this, you have, instead of a god and a religion, you have something like human dignity. And from there you develop principles that say, well, human dignity calls for whatever things, and this is very close to what a human rights discourse is. And then on another level, you would say, okay, you have something like in state law, you have something like a democratic legitimation for law. You say this is the law that is being made by representatives, that is the interest of the community, of course, with majorities and minorities and so on and all the struggles. But there is a different kind of legitimation for the idea of the authority of law and why law has authority at all. And I think if you go into the question of communities, personal laws, it's the same idea. It's the question. So I think why should this have authority, in which way? And then I think, Morshed, with your example of the inheritance law, this is something where you can so beautifully see that also in the current state law corpus that we have. I mean, women's rights to vote, women's right to inherit, women's right to whatever you call it, those were all struggles that had to be somehow framed then in the language of law to say, well, no, but we want this to be a legal thing to be here. This has to be a legal thing. Now, if it's enough to have a legal right is a different story, because even though you might be entitled to vote as a woman, it still means that you might not have, I don't know, enough funds to fund your own political campaign and become the next presidentness. But it's I think that the question of how do you ground this authority, and that's where I would really push back against Vlad, your idea of some external law somewhere, because that would always invite some idea of a universal good or universal something floating around that can be invoked in order to justify things.
I mean, for me, the way that when I think about the law, it's kind of emergent out of people's interaction and relative postures, positions, cultures, you know, and so in this case, like the lens that I think is most clear is legal argumentation, because legal argumentation is a really great example of how law takes advantage and taps into your legal matrix and the things that you find compelling. And whether it's X, Y, Z, whether it's in religious law, or personal law, or state law, the kinds of arguments that you make are different. The kinds of arguments that land are different. The kinds of arguments that stick are different. And when someone from outside of your internal legal community is coming to you to say, look, you're causing problems, they're going to have to find legal arguments that you find binding. And where that authority comes from has to do with what arguments are legitimate to you. And that's not just a matter of you know, like the law's authority. That has to do with legitimacy in your mind and as far as you perceive it. And so when you receive a legal argument, it's not an appeal to some law that's somehow, you know, like some God outside of you. It's kind of an appeal to your legal judgment about how you perceive conflict playing out and whether or not you should adjust your position as a function of this argument that someone is giving you. Now, not all law is based in legal argument. I'm just using this as an example to show why ontologically there is no such, you know, like authority in law that is somehow this one unified grand thing that exists as this monolithic, centralized, like state-like thing.
I mean, I think, no, go on.
Sorry, Anuj, like it's just on this point. I think this discussion, and it's a bit deliberate why I chose this particular sociologist to sort of to connect with this sort of Austrian theme of having Hayek and then having Ehrlich and other and then also Kelsen in this discussion. But one of the criticisms that Hans Kelsen had of this very broad conception of living law is that he said that it confuses the empirical observation of what law is and the more normative idea of what law ought to be. And I think it links to this discussion because of the fact that it doesn't clearly delineate like where then law can end. And thus it makes it conceptually less useful to actually you know how, like in what context you are talking about law anymore.
I don't know. For me, like there's clearly no bound on where law can go. I mean, anywhere. So I don't know why you would want, and why actually I would go a little further and say that it's actually kind of lawless to try to bound law, to say, look, law should only ever be in this scope, and if it's outside of the scope, it's not law, because then you're creating areas where people aren't going to be constrained by law, at least normative, at least nominally, and therefore they can act kind of like assholes. Like, no, let me take it back. Like, they can act completely unlawfully if you try to restrict law to only be operative in some realm. I mean, like, I think it's, like, for example, very wrong to say that only state law is law, because then there's all sorts of lawlessness that people get to engage in without any recourse to any kind of legal argument, because that is just not allowed in that scope. So I'm not sure if it's useful or even lawful to try to bound law like that.
No, I mean, I'm not like taking a hard stance on this issue. I think it's useful to look at this because of the fact that how people have tried to sort of redeem this idea of living law is to try to say that, okay, if we are going to use the term law in a way that is recognized by people from multiple backgrounds, including lawyers who look at law as state lawyers, to say that, okay, can we distinguish between what we are calling legal norms based on a degree of institutionalization? So whether, for instance, a set of norms pertain to, as you were saying, about argumentation and interpretation, about, you know, there's that there being a process of creating this sort of new norms, and this aspect of enforcement. So if there is a coherence about all of these, then maybe that is, gravitating closer towards speaking about a legal framework or a crypto legal framework in this particular discussion, and those that don't provide for this, and thus end up becoming, matters regarding, for instance, manners and fashion and so on, rather than something that is, because I mean, one of the issues is about how do we, understand whether something is predictable or not, or something that we're going to see that, okay, it's happened this time, it will happen again in the future. These sorts of, very basic Polarian ideas of what law, what law is, right?
And I
I
think
think
that
there's
I think
a
people make a really common,
go on,
sorry,
go on.
sorry, Anuj. I,
No,
I
go on,
I
go
just have an obsessive thing that people make a really common mistake of trying to have legal certainty at the expense of legal security. Like, they'll just be like, I want this certain result, which really sucks, as opposed to being uncertain. And I think if people prioritize, like, legal security over legal certainty, they'd have a much easier time. And because, like, there's a lot of actually insecurity that comes from legal certainty.
I think there's an interesting angle on this. If we look at, we were talking about the subcontinent in India. The origin of how it happened was kind of a proto-secular movement. So when the Islam started growing in its theoretical background, one of the things that they were always obsessed with, because I mean, in some ways, the meaning of Islam is submission to the kind of law of God or will of God. There was a lot of jurisprudence happening. So one interesting angle is when the leader and the king of India, non-part of India, especially became Muslim leader, they were quite hell-bent Islamic Jewish thinkers that this law, Islamic law, should not apply to everybody in India who are not Muslim. But at the same time, for them, it's like living law. For them, law does not just pertain to some limited thing which you think happens, say, on certain metrics, but even the way you conduct yourself, you talk to each other, the way you gesture, everything comes under that kind of thing. And this is why they realize that we need to codify all of it, or at least understand or build a framework. And they were doing a lot, but at the same time, they were completely not touching those who were not Muslims in India. Because the idea was, and this goes back to the constitution of Medina that happened during Muhammad, the Prophet's life, is that because we are, if somebody is not Muslim, they have a different source of authority. So we have no authority on telling them what should be the law. So this is why there were a lot of, for example, spaces specifically meant for Jewish people, example. So They took that idea, and in India, they did not enforce anything on, say, non-Hindus, but that actually encouraged Hindus to start codifying their things too. So in a kind of interesting way, like because it was considered law is much more than what, say, they're talking about the sociology of wrong and that they Morshed and Vlad, you were talking, because Islam kind of took a living law example, they kind of had the almost opening to accept people will have their own personal laws also, because law was much more than just what happens.
Cool.
I think Vlad wanted to say something right before Anuj
Oh no, I got
spoke.
it
Yeah.
out. I
Oh,
totally got
okay.
it.
Okay. Yeah. Um, so I think we, I think that this authority point is also an interesting one, and that Andrea brought it. I'm curious what others also think of this issue about whether, and we heard from Vlad a bit about this as well. So I think it would be nice to hear from others about how they see this issue of authority and you know the authority of law being essential for being able to even identify what a law is and what a law is not,
Well,
what isn't law.
Can I scope this specifically to crypto law? Like,
Yeah,
how
of course.
is crypto law going to have authority / legitimacy, and not just, but is it necessary? To what extent is it necessary? Is this other question, because I don't want to buy into the assumption that it is necessary to have authority or legitimacy for law.
Yeah.
Necessary for what? For what exactly? For it to be of effect? For it to be a matter of
Recognized as
practice?
law, for example, to tie into our first conversation, or I'm not sure.
Okay. Yeah. Sure. Yeah. Okay.
Question that is just kind of coming into my mind, and just for context, I don't really work in law. I have a philosophy background. Blockchain is also sort of new to me, but we're throwing this term around a lot, law, and we're applying it to so many different domains and questioning what is, but what really is law and what purpose does it serve? This is a really foundational question, and I wonder if that might inform how we then think about crypto law and what it should be.
I have an answer. But and I don't know. I have a ready answer, because like for me, like I've looked into this super obsessively for the purpose of crypto law, and to me, law, the point of it is to manage interpersonal conflict, and then whenever anything uses law, like for example, if you want to have like a plan for your society in a civil law setting, the reason why it's law isn't necessarily because of what you're trying to do with it, but because you're using interpersonal conflict to achieve it. And that's why it kind of takes the legal form. So the legal form is all about managing conflict. And then law is kind of, all this huge aggregate sum of all of this stuff that manages structures, operates on conflict, etc. And so law is kind of abstract, complicated, incredibly complex, probably one of the most complex, if not the most complex thing I know how to think about at even a little bit, or at least like conceptually. But the point of law, I think, is to manage interpersonal conflict.
So that's an interesting frame, Vlad, and I would suggest how I would think about law, right? Is that law, the purpose, I think, of law is to be able to create some sort of guidelines. We're trying to create some sort of guidelines for interactions between people that allow for the flourishing of our society and people's lives.
For me, that's a particular kind of civil law pattern where we kind of try to agree on how things should be so that we can all work together. And that's like a kind of, to me, a very particular extreme case of like where we need to agree on how things should be in order to manage conflict. Whereas like most of the time, I think that level of extreme consensus is not required for law. And it's not, I think, the experience in the courtroom as much as it's the experience in the legislature.
I wonder what other people's thoughts are on that question. So is, you know, how do you frame law, and is it about managing conflict or something else?
I mean, when it comes to managing conflict, Grace made a comment yesterday that there is like a crypto organization that had a dispute, and even though they are forming a dispute mechanism that is based on blockchain, they are still pursuing suits on the traditional court. So my main question would be, what does it actually mean when we say, you know, we need crypto law to actually manage disputes? Does that mean that we're going to be using the infrastructure for managing disputes, or is it just that, you know, we're forming now the social laws or social norms or whatever we want to call it?
So I mean, immutability manages disputes by kind of convincing everyone that no matter what happens to them, they're not going to be able to change the protocol as recourse.
Or that's very, very particular question. That's like one specific problem, and that is the immutability and how we change it. How
So I'm just giving an example of how it happens today in crypto law.
So that's almost like the question of how often or what majority we need to change the, let's say, civil code.
No, because I mean, that assumes all sorts of backdrops about, for example, citizenship and being able to count people, identify distinct people. I don't think it's that analogous, but I do think of it in terms of, there is some analogy in terms of this question of what does it take to change something, which is kind of very much a legal question.
I mean, another thing that I think is relevant in the question of what should be called law or can be called law is when you think through any liberal theory of the state that comes up with this idea of the separation of powers, of different branches of government that are in checks and balances, and that because that is the case, somehow the state then has the legitimate monopoly of violence. So I think if you think law, the other question to always think is the question of violence, is the question of enforcement. You have the word force in enforcement. So I think when you think of the crypto space and of this example, why did they choose to go to a civil code after all? It probably depends on what they wanted to get, and they probably knew that they will not get that through whatever kind of decision in the dispute mechanism that was available. So whatever they wanted to have, I don't know what the conflict was about, but I can assume that it is about seizure of assets. It's about something where you need some sort of force to be able to grab that kind of thing, and that's usually what the state does, and that's where the state comes in as the enforcer of these things. So I think I would say that one of the turning points for the question of how to think about law in the crypto space and what kind of law is needs to relate to the question of enforcement and the possibility of enforcement.
Yeah, I totally agree. And but I also will say that, like, I don't believe that any state has the possibility for enforcement in crypto law, and that's kind of by virtue of the norms that we have in crypto law today, as much as the ethos of crypto law, as much as the basic institutional structures. You know, there's a really deep barriers to state law in cyberspace and in crypto law and in environmental law and in a bunch of global law areas. And so we have to have notions of law that can create enforcement despite the lack of subject to the rule of law that states exhibit.
So I do agree with that, because there is I mean, we are becoming more and more globalized, and by that we are creating norms or a society that surpasses the borders. And if we're constantly going to be creating the legal system and relying on the notion of a nation state, we're not going to make a favor to ourselves. I mean, there has to be some sort of a revolution. But I'm curious whether, Andrea, you perceive that as a modern legal theory, or is it because, I mean, when I think of laws in a broader sense, there's Newton laws, and even the word economy economy comes from oikos and nomos, the Greek word for laws and household. So it's basically the laws of the household that we today call the economy. And it's like, we have this broader economy of the whole globe, and we still kind of use that economy as the household rules that we have for our planet. But we don't really perceive that word in such a meaning. And we don't really, like lawyers don't usually see the Newton laws as something that would be enforced by the state either, because there's nature that enforces them either way. But I'm just curious whether we can really think of laws that are much broader and that are not going to be effectively enforced by the state.
I think there's a beautiful, and I'd really recommend anyone who's interested in this to read this essay by David Graeber called "Provisional Autonomous Zones," and it's in one of his books, which I think is available online, called "Possibilities," where it's basically based on his PhD research in Madagascar, where he looks at a particular community which, while having all of the, what looks like all of the symbols, all of the apparatus of a state. It has a police station. It has some guards. It has, people going around who look like police officers. It has a process of registering marriage documents and property-related documents and so on. But because of defunding and because of the fact that they were also very lethargic about actually implementing the sort of French origin state law, people, all of this was very performative, and what really acted as living law to govern both disputes as well as just the transaction of property was interpersonal relationships. And what I thought was very interesting there is that even when it did come to new types of disputes, the whole way that they decided in a community of how to resolve it was not with looking at, okay, what does the state law say? We should go report this person to the police or, take this to a court. It was that, how do we resolve this internally by ourselves? And that's where, I guess those interested in how govern, how anarchists would govern a system, that's where it becomes very, very interesting, because in comparison to, for instance, what state law was allowing, this sort of self-governance system for resolving disputes was more inclusive. And so I think it's a lot about how do we actually design something like this so that what is offered is not just something that leads to some sort of brutal brutal system, but also what can we, I think, learn from other examples that have existed of these sorts of autonomous spaces for creating something that can act in parallel to a civil law system.
I think what David Graeber was also saying in that is, I think it was Madagascar, right? If I remember. Yeah, Madagascar. Yeah, that it was interesting because they had a kind of a cargo card state apparatus by design almost, because to kind of still maintain the modicum of having looking like a state, like every other state, especially in the Western world, because it was just a modicum, just a cargo card, it was actually not able to enforce anything on anybody. But it was more like from the bottom up, like people were on the ground figuring out the interpersonal relationships and their conflict. So that's interesting because I think there is, in a sense, a kind of a performative uh, cadence to having a kind of a just a modicum, so it looks like everything is under some sort of a overarching thing that is taken care of, and you have all the things like police station and everything. But it's also important to know better and to not actually, I mean, from the anarchist perspective, know better and not to actually make it act like it's a real apparatus, where people could come in. So it's not enough to just have the people do their thing and not have the kind of performance theater, I would say. So I think that was a very interesting thing. Sometimes we get caught up in the theater and we start acting as if it's a real thing, especially in crypto, right? So especially when people get together and try to, get to a kind of resolution or something, we get so serious we forget the theatricality of it, and not let decisions come from more from the community.
I mean, maybe another pair of terms to spark the conversation is formal versus informal. If you think of these examples of community-driven organizations, I think one of the areas in which in the development discourse this has been very big is this idea that all property in the global south should be formalized so that people can use their property on the markets to leverage against credits, to leverage against whatever. So if they just, so to speak, were able to unlock the value of their assets that they are already holding, then they could all become part of the economic system and they would all be alleviated out of poverty. So this is Hernando de Soto, very famously for 20 years advocating for this. And I think that with blockchain, this has had quite a resurrection, this idea, because now you have the perfect instrument to do that. But then, of course, if you look into the question of how housing and living is organized in many places in the world, you do not have this formal mechanic system. So formalizing property means actually creating different property relations. It doesn't just mean we somehow use something and represent it one-to-one as it is, because you have arrangements that are much more flexible, that work in different ways, that have ways of living together that are not, that do not lend themselves to the idea of exclusive property or lease or whatever else of kind of words we have in law to do that. So if you then suggest something like that, then this is like a very violent way of reorganizing property in certain areas. So and there really, I think the mode of thinking about it is not necessarily around the question of state law or not state law. It's really about the question of formalizing things into very clear, identifiable titles that could come from any community, or that drive or that desire could come from anywhere. So just as a provocation, I put it on the table also within the blockchain space. What is a desire is a perfect formalization in some sense. If you want to have it as a digital asset, if you want to have the digital twin, you have to have it defined in very clear terms, and all informality either has to become formalized perfectly in some way or is out.
Why would it have to be formalized?
Oh, in order to be able to have a representative digital twin of some kind, if you want to leverage it, if you want to trade it, if you want to do something with it, then you have to have it formalized into.
I mean, maybe if you want to have it recognized by like someone who only recognizes formal forms.
Yeah, so if you want to use it on a blockchain, if you want to use a blockchain in order to trade, that's in order to do something.
This is a really interesting example, Andrea, because of the fact that, like, I visited the Dutch Cadaster, so the land registry, a few times, and one of the things they do as a way of like this small or relatively small organization ending up becoming quite a commercially successful one is that they do commercial advisory on digital land registration, which now involves also like a blockchain component, or at least has been discussing a blockchain component too. And one of the examples they gave was going to many parts of the world, and for the first time formalizing, like let's say a parcel of land that is owned by a community, which before was done verbally or was done through a shared understanding of where one's property ends and another one's begins. But one of the interesting things that resulted from this was that this formalization led to like a whole spate of new disputes. Instead, because of the fact that while there was this sort of tacit understanding that, okay, my boundary ends here and your one starts there, when having to actually put a one-to-one token equivalent of this, or a digital representation of this, it forced people to enter into conflicts that might have been perpetually deferred. And I think that's also like I think an interesting side effect of this process.
Yeah, I agree. I mean, Morshed, this is exactly what I had in mind. I think this is yeah.
Isn't that an argument that, wait a second, isn't that an argument that we don't need to formalize stuff, and that formalizing stuff creates unnecessary conflict in many cases?
Yeah.
Or maybe like the the imposition of property rights in a particular way in order to, have as your core development policy might not be the right way to go in places.
Why focus on property rights? Why isn't this an argument about legal forms and legal positions in
Well,
general?
like for example,
imagine you were
so
to
like,
ask me to formalize my legal posture. Like that would be weird, right?
so I
Sorry
think
to
what
go, John, go.
no, I'm quite, I think the session's wrapping up or something. Alyssa, what were you going to say?
Are we only having 3 more minutes?
Sorry, what happened there?
Yeah, we just have 3 minutes.
Oh, okay. Here's just, so what I'm saying, Vlad, is when, so one thing is I think there's a sort of like, it's an aesthetic exercise how we separate like the legal from the social, or from in some ways, or formalization from non-formalization. And so it's interesting to look at how those things are created and sustained, and who, in what context. And the conversation of formalized and not formalized, I see as a way to sort of step away a little bit from the baggage of state, non-state, or trying to create these domains of regulation, or argue over whether it's spontaneous order or set up and stuff like that. And in the question of that formalized or unformalized, as I understood it, like De Soto, for example, in that context, was about an argument about how you should sort of structure development policy post 80s, 90s, when there was a decision by international investors in Western states after the NIEO of the 70s and post decolonization, and then the oil and all that sort of stuff, of how to discipline those countries, and about how to recenter power outside of the UN General Assembly and into an international contractual regime of dispute resolution. And a big part of that was to have a certain way of thinking about development and foreign aid through formalization of property rights. And that shifted who the actors were and who got to be experts. And so just to wrap up, and in that case, it was a big failure for a lot of reasons. One was that the banks lent to people with income rather than like poor properties, and the properties were alienated, right? Just empirically. So in crypto, whatever that is, like it's also a shift of authority. It's a certain way that the orientation gets talked about. It's like different people in the room. It's computer engineers rather than traditional economists suddenly, and stuff like that. So anyway, there's so much to unpack, but I think that's, for me at least, when the conversation shifted to formal versus non-formal, was an attempt to like come at it from another direction, that it just highlighted the fact that how we get different vocabularies come entrenched with certain sort of roadblocks or disputes, you know what I mean? Stuff like that.
Yeah, I like it a lot. Just one little thing is that I know, like in India, when they had this whole push, and still they have this rhetoric, we are not formal enough in property, and that's why they developed and all that. It's a very big rhetoric. And many times it gets lost in who gets to stand in the registration line the first. They get to have it formalized. So and as you were saying, John, so this is always scary, and also at the same time, people who already have a lot of power in an informal way, they don't want formalization to happen because they feel they might lose some of that power. So there's also both sides of the equation. So and also, which happens in crypto a lot, which is this drive of tokenize everything, like let's tokenize this conversation also, and which could be in some ways useful, but I mean, that would be claustrophobic, I would say, if you give form to everything. So, yeah, I think this is a whole other conversation for itself, but I think very fruitful one. So, thank you, Andrea, for the provocation.
Yeah, thank you very much. And I hope that we can continue this conversation tomorrow and hear more from everyone about this, as well as the new topics that we're going to have tomorrow as well. Hopefully also from others. Yeah.
Yeah, and be sure to give us 5 stars on all rating apps. I don't know.
Really, that's what I wanted to do. I wanted to say you guys did awesome. I love the Notion explanation. You did a lot of work in putting this together. Thank you very much. I will rate you, Anuj, in all my invisible network.
I love it. That's, one little thing is also a personal thing for me and maybe for Morshed also, because right now we are in a dictatorial state in India where the government wants to do a uniform civil code and not have personal laws. So I'm very passionate about this, and we are doing a lot of groundwork to fight that, lot of activist groups. So I hope they don't win the legal fight, but
Yeah, good luck. But if there's any consolation, if they do it, it won't be very effectual. So you'll get to still have personal law and all sorts of other legal forms.
I hope so. They're trying to take citizenship away, by the way, of mine. There's also that. They took my bank accounts. So I will see what happens there.
I think as a last point, I just reflecting on what John and Andrea were saying about formal and informal, is the fact that it's so fascinating that a lot of what we are discussing about crypto law might fall within an informal space, but how blockchain is so often used for formalization processes, not just for land records, but also for birth. Like the proposals are all about this, right? Like land registration, birth registration, registering refugees. Like it's and how in a way like this can end up creating a whole new sort of I guess like a fear of how this can lead to power imbalances as a consequence. Yeah.
Thank you so much.
Thank you.
Cool.
Bye. Bye-bye.
Thanks, everyone.
Thanks, everyone. It was fascinating.
Bye.
Bye, everyone.
Bye. Have a good day.
Ciao.